Okay, so I'm Bart Strzok, and today we're going to talk about the FAR as-is contract and avoiding common realtor pitfalls. So when I first started in this business, who's, I know I could put everybody on mute. Will everybody please turn off your sound? Okay. Anyway, so when I first started in this business, we'd see a new contract form every 10 years. Now we're starting to see them every 6 months. Over the past year, we've been subjected to the settlement, Florida, the realtor settlement on compensation. No longer do we use the word commissions. We've seen statutory changes on disclosures that have to be made, and the practice changes over time, especially with the economy, as you switch from seller markets to buyer markets and vice versa. Plus, we're in a very diverse state. So whereas we here in South Florida typically use, I wouldn't even say typically, I'd say 100% use the as-is contract. Upstate Florida, more than 50% of the contracts are being done on the standard contract that includes repairs. So there's a lot that we need to talk about today in a short amount of time, so I'll get right to it. Is Chris Trujillo in here yet? Okay, Nina, let me know when Chris comes in. I don't see him.
Okay.
Okay. All right. Anyway, so I told you about me. So first thing we're going to talk about is understanding key terminology and critical dates. Does everybody see my screen?
Yes.
Okay. Do you see it now? Everybody see it?
Yes.
Okay, good. All right. So critical dates. That's the important thing. So these are the things that realtors screw up. That's what we're going to talk about. And how do I know that? Because first of all, we have problems during closings, and then the files come to me when it doesn't close and someone wants to claim the deposit or someone wants to sue the other person for damages. And sometimes I have to say, the worst thing I have to tell a buyer or a seller, which I really can't say because you referred the file to us, is your realtor screwed up. You don't want me to say that. So let's learn to do these things and not screw up, okay? The problem is that the 20 some odd people of you who are here, you are not the ones that screw up because you come to education. It's the ones who don't know that they need it or don't care are the ones that we have the issue with. Okay, so we go to line 403 of the contract, if everybody could see that. Okay, time. Time is of the essence is all contracts. That means that there is no, okay, you have 5 days to do this from this notice. It means if you don't do it on the date due, F you, you're screwed. That's what that means. We use calendar days. For some reason, many years ago, some of the contracts used business days, which was ridiculous. We use calendar days in computing time periods. Okay. Time for acceptance and the effective date on the contract are exempt from all of these rules. It sounds like you might have switched to a different, I don't know what that was. I'm speaking English. Boy, world is getting complicated. So anytime, so how do we count dates? The effective date of the contract is day 0. The first day ends the day after the effective date, okay? And every day counts, okay? Except if it ends or occurs on a Saturday, Sunday, or national legal holiday. A national legal holiday, it even gives you a perfect description where in the statute is, and for convenience sake, go to federalreserve.gov, and that'll give you the list of bank holidays, and those are the national holidays that don't count. If the banks are closed, then it's on that list of Federal Reserve dates, that's a national legal public holiday. And if it ends, only if the last day of a time period ends on a Saturday, Sunday, or national legal holiday, it goes over to the next calendar day, which is not a Saturday, Sunday, or national legal public holiday. Oh, look, we have a comment here. National legal public holidays is defined and the banks are closed. That is different than, for those of you who do property management, that is different from the definition of holiday when you do an eviction, when you serve a 3-day notice, when a 5-day summons gets served. Those are holidays as defined by the clerk of the court in each county. Those are different. So what does this mean? This means that if my effective date of the contract is on a Saturday, Sunday is day 1. These dates only apply, this counting of dates, time, only applies to everything other than the effective date and the time for acceptance. If you prepare a contract that says it must be accepted by Saturday, then it must be accepted by Saturday. And we'll go over the terminology of that in a minute. So time does not apply to effective date and time for acceptance. Remember, fill in every line, even if it's the default number. Fill in every line. Show that you read the contract. Make sure every blank line. My program doesn't have it, but all of your programs have. Let me show you. All of your programs have a star next to the line number where something has to be filled in. Mine doesn't have it. Make sure there is something filled in on every one of those lines. Okay, where do we run into problems? So we're going to talk about understanding key terminology, calculating critical dates, and so here's critical, right here. The washer and dryer is not included in the personal property. So if it's included in the sale, you must include it, okay? Many realtors do not check one of those boxes. And the escrow, yes?
I'm going to interrupt you on the washer dryer thing. Many times people have a refrigerator or a freezer or both in the garage that they don't want to include. But in that personal property, it does say refrigerators. So it does have the S, so they are included. And if they want to exclude those items, those should be done in section E and specifically put in the contract as well to protect your sellers.
Yes, it does. You're correct, Adam. Thank you. So you must check one of the boxes on line 30. So many of you don't. Escrow agent can never be to be determined. You must name an escrow agent. I don't care who it is. I don't care if it's the closing agent. I don't care if it's the brokerage office. I don't care if it's a third party. someone has to accept that check, accept that wire, accept that deposit, and you must provide the contact information for the escrow agent. As we'll discuss a little later, the escrow agent and the closing agent are not necessarily the same party. So, where am I? See, check a box. What if not paid must be? Okay, so if there's an additional deposit, put it in. Terminology: deposit refers to the initial deposit and the original and the additional deposits. All deposits paid or agreed to be paid are considered deposit. So both are at risk, whether paid or not. So if the buyer decides I'm just going to forfeit my initial deposit, and we'll talk later about getting a good enough deposit, a big enough deposit, that buyer is still at risk that the seller could come after them and sue them for the rest of the deposit that they didn't pay. What we talked about time for acceptance. If not signed by buyer or seller and executed and delivered to all parties on or before Saturday, July 12th, 2025, it is Saturday. It does not go over to Monday, okay? Because time for acceptance does not apply to that rule. And then the offer is automatically deemed withdrawn and deposit shall be returned. Usually no one makes the deposit till it's accepted, but that's it. You cannot accept an expired offer. It is withdrawn. There is no longer an offer. So if you accept it after the date for acceptance, there is no acceptance at all unless you prepare an addendum or write something in accepting that both parties agree to accept an expired offer, or you change that date for acceptance and everybody initials it, okay? This is one of the things when we get in say key title, when we get a contract in, this is one of the things that we look at. Do we have a real contract, or can someone walk out at the last minute and say, oops, we never had a contract, look what happens. I don't know anybody else that does that. We got another comment here. Oh, see line 430 per time. We did that. Now, what is the effective date? It's the date and when the last one of the buyers and sellers has signed or initialed and delivered the offer or final counter offer. So how many of you sometimes do not date all initials? I know on electronic signatures, most of them automatically put a date and time in that it's done. But not everything is done that way, and not all of them do it. So how do we know the effective date? And it used to be that, well, I would email them, and the date on the email would show us, look, here's the contract, we have a deal. But we don't always get that from DocuSign or things like that, where it's automatically transmitted. So make sure we get that attached to the contract, the DocuSign, as to when the last person initialed and it was delivered. You can't, if you initial a contract and I sit and hold it for 2 days, it is not a contract until it is delivered. Okay?
Barton, may I ask a question on that?
Sure.
Because I've heard as a transaction coordinator, I just want to clarify. So whenever it's signed and it's delivered, is there a time frame? Is it like before midnight of that day? Like say they sign it at like 7 p.m.
Doesn't matter. It's a 24-hour period.
Okay.
No longer do we have time cutoffs in this contract. You know, if I deliver it at 11:59 p.m.,
Mm-hmm.
that's delivered, and the next day is day one. Okay?
Okay, thank you.
I believe one of the addenda, which will be next month, still has 5 p.m. in it. But we'll check that out next month. Okay, so you must check a box. The closing date. The closing date must be an exact date you need to put in there, or a date that is objectively ascertainable. So it could be 30 days after loan approval. So that's ascertainable once we know the loan approval date. 30 days after anything, that's ascertainable. You just can't say to be determined. You can't say on or about, because if you say on or about, that is not an ascertainable date. You can say on or before, but that is very misleading and causes problems. So earlier versions of the contract from the last century used to say on or before, but now it just says shall occur on. And there's a reason for that, because if you put on or before, it's misleading to the buyer and seller who thinks, well, I'll just say we can close early. No, both parties would have to agree to a before date. So if that's going to happen, they could agree, and it doesn't have to be in the contract and confuse your parties. Okay? So on. Don't put in before and never put in about. Okay? There are automatic extensions to the closing date. Okay, how do I get that off? There we go. Okay. So if closing funds are not available from the lender due to consumer financial protection, that's because you have to sign the disclosure 3 days before the closing, and sometimes there's a change, and you have to wait 3 more days with some complex rules, then you could have an automatic extension if, number one, it's a financing deal, 8B is checked. It doesn't apply to any of the other checked boxes. Loan approval has been obtained. Okay, assume we have that at 2. And lender's underwriting is complete. So if the lender is not ready, hasn't completed its underwriting, you can't just say, okay, I need an extension. The lender is not ready to fund this deal. That automatic extension is solely because the TRID, the disclosure, has not been signed 3 days prior to the closing. Okay? So unless you could present something that says, look, we've completed underwriting, it's all ready to go except for this. And a lender is not going to give that to you unless it is true. Okay? So it's no automatic extension anymore that the lender is not ready to fund. You've got a certain period of time, which we'll discuss, to have the lender ready to close. And so you better be using a lender who you could rely on so that your client's deposit is not at stake. Okay? All right, next we have deposits. We did. Let's talk briefly about default provisions, because for some reason I have deposits and default together. So I guess because they both start with D. Okay, default. So what happens if the buyer defaults? Buyer doesn't pay their second deposit. Buyer doesn't show up at closing for whatever reason or another. Then the buyer has, and this is something you need to consider right up at the beginning. That's why I'm telling you why deposits, and now I remember why default and deposits come into the same category. because if the buyer defaults, then the seller has two choices. The seller can claim the deposit, and when the seller claims the deposit, it is agreed upon liquidated damages, which means that's it. I get the deposit. I could sue for nothing else. That is my sole remedy. Or the seller could sue for specific performance to force the buyer to close on the deal. And I don't think any attorney who is worth more than 2 cents would recommend that to a seller to do. So let's start. So if your client has had the property off the market for 2 months, waiting for a closing, maybe kicked a tenant out and hasn't gotten rent for 2 months, maybe has moved already, and it's now vacant, you need to collect a big enough deposit to compensate your seller if the buyer doesn't close. Does everybody understand that? You know, the old rule used to be, the rule of thumb, 10%. And everybody got away from that. And no longer is it the rule of thumb. I don't want to scare this buyer off by demanding 10%. Well, you know what? If the buyer is scared off by it, then there's a reason why the buyer is scared off by it. Now, understand it's a buyer's market, and you have to make some concessions to some extent. But I know brokers, realtors who will not take less than 10%, because what happens is when the deal falls apart, they're going to turn to their realtor and say, how come I'm only walking away with $2,500? You know, I've already made 2 mortgage payments that total $6,000. What's going on here? Look how much less I've paid 2 months of taxes, which is going to come out on prorations. My interest, my electric bill for this vacant house, all these things, take all that into consideration when you're asking for a deposit. It may not have legal ramifications for you, but certainly customer service that you give, you will be much more appreciated by your sellers for your listings. What happens in seller default? Now, there we have options. So if the seller does not close or breaches the contract, other than they cannot make the title marketable in time, which is a whole different issue, then the buyer may elect to receive return of the buyer's deposit and not waive an action for damages resulting from the seller's breach. So the buyer can both get the deposit back and sue for damages. Now, a lot of times when you cancel, you automatically send the form cancellation of deposit and deposit release, which releases all parties from the contract. So that takes away any ability of the buyer to sue for damages afterwards. So you have to consider, is that what I want to do? How much money did my buyer spend, or what's their losses as a result of the contract being breached by the seller? You know, the return of the deposit may not be sufficient damages for everything the buyer has done. You know, if we're talking about vacant land somewhere, the buyer has done extensive inspections, soil percolation tests, and environmental tests, and all sorts of expensive investigations, due diligence of the property, there may be some serious issues here. What if the buyer, if the seller decides at the last minute, I'm not closing, the buyer's personal property is already on the truck from their old house, and now they have to go into a hotel, put their goods in storage. Just getting back your deposit is not compensation for all the damages if the seller willfully refuses to close. So before you send out that deposit cancellation and release of escrow, you need to seriously consider if that's the proper remedy for your buyer, if the seller, or the buyer can seek specific performance to force the seller to sell. Now, that's a lawsuit. That could be expensive. That could take 2 years. But remember, if the damages are sufficient and an LLC is the seller, that LLC is not going to be there in 2 years at the end of your lawsuit to get damages. The only way you could prevent the sale of the property to someone else is by filing that lawsuit and recording a lis pendens. And then a lot of times the seller will come around and say, we need to work this out. But these are things that have to be discussed with your attorney, not necessary. So here's one of the reasons to use a attorney-owned and operated title company as your closing agent, because there's a lot of serious discussions that go on here. You know, if you get to the default and dispute resolution, not an attorney title company licensed by the department, they should be out of the picture at this point. You should be dealing with attorneys, and you should not be giving the advice on what to do as realtors. Okay, I see too much of that where the buyer or the seller comes in all hyped up with anticipation of the damages they can get or what could be done, because the realtor has built them up so to, oh, you're right, we're going to get them good, I'm going to take you to the best attorneys in town. And I appreciate that if it's us, but we have to tell them, no, you can't do that, because here's what your contract says. Okay? Anybody have any questions at this point? Dispute resolution. So dispute
Bart.
resolution, someone there? Okay.
Art, Dawn,
Yes,
how are you,
go on,
sir?
go on.
Yes.
Good.
So when there's a breach, and maybe we can take
Go on,
this
I
up
like
a
the way
little.
that hair looks.
Thanks. So, well, it's been a minute. When there is a breach, seller's defaulted, we do the initial letter demanding, they refuse to sign off on the release. You send the letter, we hear nothing else. What next do we do?
Well, that's what I'm about to go to right now.
Excellent.
Dispute
All right, I'll go back on
resolution.
mute.
Thank you for the lead-in. Is Chris in, Nina?
Not yet, Bart.
Okay. Dispute resolution. Unresolved controversies, claims, other matters, anything else at all, okay? The buyers and sellers have 10 days from conflicting demands to attempt to resolve such dispute, okay? Nobody could do anything legally for 10 days, okay? What do we got a comment here? This is when the agents should be working to resolve this during the 10 days for their clients to avoid legal fees. Okay? So, and in addition, the escrow agent, in my opinion, should also be involved in this, because, the escrow agent, whether it's the closing agent or a separate escrow agent, there's a lot of work involved in filing an interpleader action, asking the court, and it needs to be done. And everybody should go in there with some reasonable offers to get this settled before it has to go to the attorneys. So all of you are experienced realtors or processors, and you know how excited people can get at this point. It's a very emotional issue when you get to the point of breach of the contract or perceived breach of the contract, and I'm claiming the deposit and I want the whole thing. Okay? Well, we got a $25,000 deposit and we could spend 2 years in court, or listen, Make it worthwhile to settle. Give them back 5,000 and you'll walk with 20. Okay? That's what should be done. That's what the escrow agent should be doing, and you realtors should be doing during that 10-day cooling off period. Or you wanted this house 3 weeks ago. You wanted to buy it. You wanted to sell it. Let's see if we can track back what went wrong and see what we could do to come to a solution before the lawyers get involved. Now, all of you who work with us know I know you're going to be calling Adam or Julie or me and saying, how can we settle this? We are all Florida Supreme Court certified mediators. We've been through mediation training and we're going to give you, and I actually do mediation, so, which I'll talk about in a minute. This is when you should be working. Okay, 10 days, you can't get it settled. Buyer and seller shall attempt to settle disputes in an amicable manner through mediation, pursuant to blah, 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 blah. You cannot go to court until you have mediation. The Third District Court of Appeal in January just reinforced that. In fact, may have gone a little too far with that. But we must have mediation, okay? If I'm not part of the deal, if I'm not the closing agent, I'm a certified mediator, county court and state court. So, you could recommend me to wherever you're doing. If the parties don't have attorneys yet and whatever, I could do mediation. If they have attorneys, I could do mediation, as long as we are not involved as the buyer or seller's attorney or so.
I have a question.
Okay.
I have a question.
Yes.
Who choose, you say that you are certified mediation, but who choose, because there is two parties, the buyer and seller, but I represented the buyer and I want you to choose you. The other party had to agree because it just must have to be one mediation, right? Mediator.
So what I do when I write that default letter representing a buyer or a seller, I give them the names of 3 mediators. Please select one. Okay? And that I've never had a problem with that. Or they'll come back to me if there's an attorney on the other side, they will come back to me with, I would rather use this person. Quite honestly, I don't care. Usually we're talking about a deposit of $10,000, $15,000, which should have been 30 or 40 or 50. And we're either going to settle it, we're not going to settle it. And so, or I'll check out that mediator or whatever. You just have to have a mediator. When you're talking about, yes, if you're talking about a complex lawsuit, if you're talking about something that's going to go on for a while and you have court-ordered mediation later on in the process prior to trial, then we're talking about a different caliber of mediator.
Okay.
Here, where the court's going to appoint a mediator unless the parties agreed otherwise. Here, you can't have too much of a fight over it, okay?
Hey.
So I always recommend 3.
Okay.
If I'm not on the deal, you could always say, hey, let's use Bart Strock. He's the best effing mediator in town, okay? Okay, so, and then if you can't get mediation, then, if you can't settle it on mediation, then you go to a lawsuit, okay? And the courts are very serious about that. So it used to be that if you filed your lawsuit prematurely, the court would say, I'm not doing anything until you go to mediation. Now, some of the courts will say, you haven't done all the preconditions. I'm dismissing the case without prejudice, so there'll be a new filing fee when you get there. So it's got to be done. You can't avoid it. Even for the case where the buyer didn't put up the second deposit, it's got to go to mediation first. Okay?
Even if the buyer refuses or ignores the response to go to mediation, where does that leave you?
That's a very complex issue right now.
Gotcha.
That there is a new case about that, which I think will be overturned when it gets to the Florida Supreme Court, but it is an issue right now. The good news is most attorneys don't know about it, so it's not going to be raised, okay? You have to be pretty sharp to know about that case. Okay. So that's the story with dispute resolution. Now let's talk about the closing process and closing procedures. All right, we've already talked about. Okay, so we've already talked about that the closing date must be a date ascertainable. Standard 1. I don't even know where that is. Oh, standard I. So the closing agent who's going to designate the closing agent, and we have that information is in those boxes that you guys check: seller, buyer, Miami-Dade provision. Okay. Whatever you check, that's gonna who selects the closing agent as opposed to the escrow agent, who may be different. And I'll show that in a minute. You know, it's going to be in the county where the property is unless agreed otherwise. In this day and age with electronic closings, it may be in London for all we know, where the documents are being signed. Closing documents. Seller shall, or prior to closing, execute and deliver a deed, bill of sale, certificate of title, and other documents necessary to transfer title to the property. That's an issue. When does that come up? That comes up when, for example, an LLC is the seller, or a corporation is the seller. And you know, this investor is doing corporations and LLCs left and right to do it. And they have no minutes, they have no operating agreement, they have no shareholders agreement, they have no resolutions or corporate minutes to say they're authorized to sell the property and sign a deed. And a title company licensed by the Department of Insurance that does not have any attorneys cannot prepare those documents. So, you know, you're in Palm Beach County and the seller selects a non-attorney owned or operated title company. When the title commitment comes back and says, look, we need all these documents to cure title, the title agent has to say, oops, you better go hire an attorney to do that because I can't do it. Extra cost, extra expense. Try to get all of your ducks in a row, that everything is handled by one person, that one set of eyes sees that. Otherwise, it could start leading to more problems whatsoever. Okay?
Bart,
Yes.
I have a question.
Yes, Daniel.
I noticed that in a lot of transactions, I will say the majority of transactions, the seller let's talk about Broward County, for example, okay?
Sure.
Not Palm Beach. Most of the transactions, the title company that doing all the closing pretty much is done by the buyer. And most of the transactions I see that the seller just going along with that title company. Very few I see where the seller chooses their own attorney, like in this case, your office, to handle their side. What would you say about the benefits or issues with it?
Well, I would say number one, you should tell your seller that they're a fool not to hire an attorney.
Right.
So remember, that title company, that's closing agent, whether it's an attorney owned, whether it's an attorney, no matter what, they're looking out for the buyer's agent, because the buyer's agent is the person feeding them the business.
Exactly.
Their job is to make the buyer's agent look good by making the buyer very happy.
Right.
And if there's any doubt on anything, that doubt is going to be resolved in favor of the buyer. Okay?
Right.
Now, Adam probably handles 90%, if not more, of our seller representations.
Right.
Adam will go through the closing statement and more often than not finds errors in proration of taxes that are negative to the seller, okay? They're to the buyer's advantage.
Right.
There are many times I will see Adam find issues with in the closing statement that are more than our fees, okay?
Exactly. I've seen that myself. Yes.
And right. And you know, if you say something, they're going to start yelling, well, you're not an attorney, you don't know, blah, blah, but we do.
Right.
Adam can be quite forceful.
And
Um,
the bigger issue, Bart, in addition to the fees, is when the closing agent's preparing documents for the seller to sign, many times, whether it's in their affidavit forms or their miscellaneous documents, they put in additional language that's not legally required for the seller to sign, where the seller is agreeing that even after closing, they'll indemnify and hold harmless the closing agent and title insurer for damages that they incur for errors that they make. So if they screw up, they sue to have the seller be responsible for fixing those screw ups. And it requires the seller to pay the title agents and the title agent's title insurance underwriter for their legal fees, court costs, and things of that nature. Does it happen often? No, but when I
You
see
never know.
I immediately force them to take that out of all of their documents they're requiring the seller to sign. And if they go with the closing agent, they're not going to know. They're just going to sign that. And if something does happen later, they could be responsible for many additional fees and costs that they didn't even know that they were aware of.
and when that seller gets sued or gets the letter, you owe us for this and you have to do this, they come to me and I said, well, you signed an agreement that did it. Well, who was your attorney at the time? I didn't. I let the closing agent do it. Come on. These
Now,
guys, with the average price of a house today, I don't know what, $600,000, $800,000 in Broward County.
mhm.
You know, the seller needs to invest approximately, I don't know, $1,000, $1,250 to have an attorney represent them because
Mhm,
the world is crazy.
And
mhm.
for clarification purposes, when the seller is choosing a title company to do their side, it has to be a title company owned by an attorney, not just a regular title company, correct?
A seller does not hire a title company to represent them. A seller hires an attorney to represent them.
Right. Okay.
A title company is licensed by the Department of Insurance and is
Mhm.
not an attorney. They may have an attorney there
Right.
that does the work, but a title company can't represent a seller.
Right. Okay. I see that.
Okay?
And if,
I,
1 second. And if you notice, if you do business with us, our seller representation is all done through SCZ Real Estate Law, and our title work is done through Safe Key Title.
I see.
Two separate entities.
Okay.
I want to say something. During all my years I have been working with real estate, just one person say no attorney, seller representation. I think it's the best money invest, not only to protect the seller, I think it's only for protect us, especially in this moment. So if we explain the seller, what is the benefits, having an attorney in their side, I'm sure they take it. For in my case, most of them, just one say no.
So I have a quick
I agree
question
with that.
regarding those seller documents that your colleague referenced. Is there a section within those documents where it typically holds the title company harmless so that we can specifically look at that?
They'll put it in multiple documents usually. Usually it's in their overall closing agreement, which talks about tax prorations, correcting documents, all of those things. They'll also put it as one of the paragraphs in the affidavits, like the no lien affidavit or a gap affidavit or a continuous marriage affidavit or all of those things. So they'll usually throw it in 2 or 3 times. And sometimes they'll put it 2 or 3 times in the same document.
So how do you resolve that?
How?
It's not
take
your
their
job.
I take their documents, I redline them, I send them back and say, unless you can provide a statutory basis or somewhere in the contract between the buyer and seller that requires my seller to sign this, please remove it. And they'll fight back and they'll say something like, oh, it's standard in the industry. And I'll say, well, I can provide you 20 different documents that look very different from this. So I guess it's not so standard. Again, please provide, the statutory or contractual basis. And eventually they cave in. They always do. Sometimes they'll come back and say, well, my underwriter requires it. Great. Give me the attorney for your underwriter's email address so that I can cover it with them. We go back and forth. I've done this so many times. I've probably had to change that language 20 times in the last 3 months on deals where we represent sellers.
So when we're looking at title companies, there needs to be, just being attorney owned and operated isn't sufficient. There needs to be a separate real estate firm associated with that title company.
If you are the listing agent and you represent the seller and the buyer chooses the title company, then your seller should have an attorney to make sure that the buyer's title company is doing things properly for your seller.
I understand, but how about in a county where
if you represent the buyer and the seller is choosing the title company, your buyer should have an attorney looking out for them for the same reasons as well. If your buyer is choosing the title company, choose us.
I understand. So, but if it's in a county where the seller chooses the title company,
then your buyer should hire an attorney separately.
Understand, but if you're representing the seller, then again, it needs to be a firm that's affiliated with a title company, a law firm that's affiliated with a title company.
If it's a county where the seller chooses a title company and you
Yes.
represent the seller, again, choose us.
But I don't think that's what she's asking, Adam. I think what she's asking is, can a title company that has an attorney on staff provide seller representation? Is that what you're asking?
Yes. Yes.
So the answer is they shouldn't be. So a title company can only do things that are incident to the writing of title insurance. So they should not be providing representation through the title company. They should have a separate law firm, or they should do everything through the law firm.
Okay. Got
That
it.
is
Thank you for,
that's the right way to do things.
thank you for that clarification.
And I apologize for not understanding your question, but we have had transactions where we are the closing agent and both the buyer and seller have had separate attorneys.
Okay.
Okay. Now I
Thank
forgot
you.
what I was up to.
The,
Okay. So
the way I see having an attorney on your side on the seller, if you're the listing agent, it's like having a Rottweiler on your side to protect you. Yeah, that's the best way to put it.
okay. So let's get past the Rottweiler shark. Over the years, many realtors turn away from attorneys because they think we're going to block the deal, we're going to throw up roadblocks and obstacles to the closing of the deal. Listen, we want the deal to close just as much as you do. Sometimes even more than the buyer or the seller want the deal to close. Because you want the deal to close because you're going to get paid. Let's talk, turkey. I want the deal to close because I'm going to get paid. we collect our seller rep fee at closing and feel very bad if we want to bill the seller if it doesn't close for some reason because the buyer defaulted or whatever. We know, just like, we know we're going to get the next deal or whatever. So we, as a title company also, we are realtor friendly. We are transaction friendly. The only reason we're going to throw a roadblock to that closing is because there is actually a defect in the title or actually a critical large error in the monetary breakdown or something, and that's where they're just to protect the party. Okay. Attorneys have given this. There are some attorneys that just want to prove how smart they are and block deals with ridiculous things. Okay. So yeah, no, I don't want to be a Rottweiler. I want to be friendly and I just want to get it done and point out what we're going to do. Adam does bite, so be careful. He could take a nip at you if you piss him off.
Only on Thursdays, Bart. Only on Thursdays.
All right. So by the way, the contract does point out that there can be a closing or escrow agent. They are separate, but collectively they're called agents. So they can be the same and they can be different. Title search, paragraph 9C. Okay. Title evidence. You could actually say that we're going to prevent title evidence at least 15 days or 5 days prior to closing. That is bull duty. I guess I forgot I'm recording it. I almost said a bad word. So you want that title commitment, you want that title evidence immediately, because there are things that might take 20, 30, 45 days to clear title. There can be some very complex things. We went through a period of time here with, you had foreclosures, you had banks that failed, you had fraud that went on left and right for periods of time and still does. There are lots of title defects. I read somewhere that at least 30% of the properties in Florida have some sort of title defect that may have to be cleared. And we've seen some, especially when you're dealing with condominium assessments and all that, could take 30, 40, 50, 60 days. We want to get that title done immediately. So let's just put in there, if left blank, put 15. I don't know, make it 20, make it 30. Put whatever you want, the highest number possible. The title should be ordered immediately upon we get that deal in. By the end of the day or first thing next morning, an attorney's reviewed the contract. We've ordered the title search. We've ordered the lien search. Everything's ordered because we don't want those deals to have to wait. Okay. Title search 18A. What do I have for that? I got a note here that says go to 18A, but I don't remember what 18A is. Okay. When you said when we present a title commitment, we have to present it with legible copies of the instruments listed as exceptions. Adam, do we get those from non-attorney owned title companies? Or do we have to ask for them?
When we're representing a buyer on a buyer rep, I ask for all of those copies and I tell them that title is not complete until I have everything to review. I can't tell you the number of times that I require them to remove exceptions from title policies because title examiners, for the most part, are lazy. And if it looks like it might apply, they put it in there without reading the actual documents. Most title companies do not send those exceptions to anybody.
But it's required by the contract.
It is required by the contract. We generally don't send them unless we're asked for them, because sometimes it can be, I mean, there are times where I ask for those documents and it's a couple of thousand pages.
Wow.
So, you know, now for some of those documents, a document could be 500 pages, and I can pretty much tell you whether it's applicable or not and what the document is, because it's the same 500-page document in thousands of properties all around the state of Florida. And if you see it once, you know exactly what it is, and you can skip to the next set of documents. But they're there, and there are times people don't think that it's a lot, but when we review title, most of the time it's the title commitment and 300 to 500 pages of documents.
Okay, so we're still doing closing process and procedures, proceedings. We also order the survey the same day. Nobody should be skipping a survey, even on a cash deal. Let me point out something on cash deals, especially if you have out of town, you know, when you have a cash deal, there's no lender saying you need this type of insurance, and to get that insurance, you have this type of inspections. You as realtors, especially to out-of-town buyers who don't know, so often I see someone comes to me with an issue, and all they ordered was a 4-point inspection to get insurance. You need to advise your out-of-town buyers, especially who aren't familiar with a lot of things, about the difference between a 4-point inspection and getting a full inspection of the property. They have no clue as to WDO inspection, wood destroying organisms. You need to explain that, like I said, especially to the out-of-town buyers who aren't familiar with our terminology. And you know, real estate is different in every single state, and Florida is no exception to that rule.
While we're on the topic of inspections, that inspection period also includes code violations.
Adam, I'm getting to that.
Okay.
In fact, I'll skip to that right now. And so, inspection period. So I know 7 is the average that everybody puts in there, and most inspectors could accommodate that. And you can cancel for any reason that the property is not acceptable to the buyer. But understand that at the end of that 7 or 10 or 15 days, unless the buyer exercises the right to terminate granted herein, buyer accepts the physical condition of the property and any violation of governmental, building, environmental, and safety codes, restrictions, or requirements, but subject to seller's continuing as-is maintenance requirement. And buyers shall be responsible for any and all repairs and improvements required by the buyer's lender. So on the 7th day, and we don't get our lien search back for 10 days or 15 days or 20 days, on the 7th day, you have waived everything in about that. So
and Weston is 15 business days.
what?
Weston for a lien search says 15
Yeah,
business.
it's a month. It's basically a month. We know that. Yeah, so we don't get it back in time. So now over the years, that's been there for quite a while. We've come up with different terminology, which I still see some buyers' agents do not put in the contract, something to the effect that notwithstanding anything, the seller is going to be responsible for compliance with all homeowners, condominium association, governmental, building, environmental, and safety codes, restrictions and/or requirements, building codes, liens, recorded and unrecorded, code enforcement matters, construction done without proper permits, whether disclosed or undisclosed. open permits and expired permits. Prior to closing, seller shall bring all of the above described matters into compliance and pay any fees, costs, assessments, fines, or liens associated therewith. In the event the seller does not or can't comply with this provision by the closing date, buyer may unilaterally terminate this contract and all deposits shall be returned to the buyer or may proceed with any blah, 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 legal bullshit. Okay? Now, you must have language like that in your contract because once you pass that 7-day period, that is it. Number one, Adam, I think we should add for it, this shall survive the closing. I think we should add to that. And what I have found out recently is that in certain parts of the state, they order a lien search, but they do not order a permit search. And so we need to add to our contracts, the party ordering the lien search shall also order a permit search. Okay? So I'm gonna, while I'm here, so I don't have to keep jumping around, I'm gonna skip to a little bit of a different topic. I always see you put in there, seller shall provide a seller's disclosure within 3 days. Okay? I finally saw the other day where it said prior to the end, within 3 days prior to the end of the repair period, so they can cancel within that period. So you need, whenever you add a clause to the contract, it needs to include something that says, what happens if they don't do it? Or how are they supposed to do it? What are the standards to do it? And I'll get to those later, but so if seller does not provide that, then the buyer will have 3 days to cancel in writing. Same thing, I'm also not seeing everybody comply with the statute 689-302 flood disclosure section. That's supposed to be done before the contract is even signed or offer made. That should be in the listing. So this language should be in there also. There's a Form FT1 flood disclosure provided by Florida statutes effective, I think it was July 1st of last year, that people are still not using. And if it's not provided, then the buyer should have the right to cancel. You give them a last time 3 days. That's important stuff. And you could designate, well, here we designated, I think there are different forms of seller disclosures available. You could designate which form you want it on. So remember, you always have to put something like that in there, okay? It's a buyer's market. Buyers are now asking for repairs. Buyer says, well, I want you to fix the roof. I want you to do that. Seller shall fix the roof by a licensed contractor. Okay? You're going to have an inspection afterwards. I just want to show you. 1 second. So.
But really quick, the flood also applies to condominiums, correct?
What? Yes.
Okay.
It applies to all property, okay? Although there are similar things in the condominium portion of the disclosure. Okay, so this is from the regular FAR contract. This is the property inspection and repair condition. Look how much language they use with repairs. Repairs shall be completed at seller's expense by appropriate licensed person and a copy delivered to the buyer or a second inspection made and provide a copy of such report. If they can't resolve the differences, then the buyer and seller shall choose and equally split the cost of a third professional inspector. talks about how to close out permits, the inspections, the walkthrough. You guys need to, if you're going to start writing in about repairs, you need to review that section of the regular contract, the repairs contract, to see how to write a section, a clause regarding how repairs should be done. I mean, it's different for stuff that could be done by a licensed person and different for repairs that could be done by a handyman who may not be licensed. But, you know, when is it going to be done? You're going to have the right to inspect it, have your inspector come back and look at it, you know, make sure they didn't do it with chewing gum, that they did it in a workmanlike manner. And again, that might have to survive the contract.
So these things that you're suggesting we put on the contract, being that it's a complex writing, it should be done by an attorney, correct?
Well, so realtors are very limited. They're allowed to fill in the blanks form, and they're very limited in what clauses they should add to, you know, if it becomes too complex, A, it may be wrong, and B, you may be practicing law without a license. So, you know, everybody who works with us knows, you know, hey, I need a clause that says this, and we'll write it for you. Okay? I'm making an offer and I need a clause for this, and we'll come up with one. And believe me, we then add it to our standard clauses like these in the contract here. I didn't rewrite notwithstanding any other terms and conditions. Adam wrote that some time ago, and it's in our standard clauses. And when we write a contract, we add it to every contract on behalf of the buyer. Not that we like writing contracts, we'd rather they go to a realtor. You know, we could charge a couple of $100. You get thousands of dollars for writing that contract.
The other thing is those clauses evolve, and if you do write something and let's say you write it for your buyer and the seller has an attorney, the seller's attorney, many times sellers' attorneys will say to realtors, you're practicing law without a license. And it's really good if you've sent it to us and we either say it's fine or we change it for you. You can say, oh, well, contact Bart Struck because he's the one who wrote it for us. And then they start to cower knowing that you have an attorney who's drafted your clauses and representing you as opposed to practicing law without a license. And we're happy to do that because it does protect you.
Well, they actually cower more when they hear Adam Zipper. So, all right, I'm going to do a few more things, and then we're going to get to the worst thing that happens in every contract, the financing provision.
But Bart, I have a quick question, really quick. You mentioned about permit and non-permitted work and is that for only for construction? So, for example, somebody replaced the pipes in the house or install a new AC unit without a permit, like many people do. What would you say about that?
It's wrong, and the seller needs to repair that. The problem is we don't know. If the inspector goes and sees an air conditioner, he doesn't know. Now, I do know some inspectors that do check permits in some cities where you can get in and do that, or they have the way to get in and do that.
Right.
But, you know, if two owners ago, they changed pipes or moved something, it didn't get permits, the seller may not even know. I mean, I have a major case coming in today or Monday, I don't remember when the appointment is, where, you know, there's so much permit issues of work done. But the first thing I did was I looked at the last deed prior to this buyer, this current owner of the property, and it was 6 months. A flipper bought it and sold it. He wouldn't have had time to do all this work. He may have not even known. And so I can't prove anything against him. So, you know, that's the difference of a good inspector who may be, bless you, Julie, a good inspector who may be able to tell work that's done without a permit. I mean, I could walk into a commercial building and know that those hallways were added without permits because there's no electrical outlet every 10 feet. I mean, that's a simple thing. In a hallway, in a commercial building, there must be an outlet every 10 feet. So, there are things that an inspector, some, good ones and bad ones, did they start as general contractors or did they just take the inspection class? Got to have a good team to support you, because if your buyer winds up with a lot of trouble and a lot of expense, it's your fault. You're not getting repeat and referral business. Okay. No matter what.
Thank you.
You're welcome. Okay. All right. 1031 exchange. Everybody's going to cooperate with that. I want to point out FIRPTA tax withholding. FIRPTA is required on every deal. Every single deal, FIRPTA is involved. And the closing agent must ask for proof that the person is not subject to FIRPTA. Get a copy of whatever it takes today to get that they're not a foreign person. They have to prove a negative. Prove that I am not a foreign person subject to FIRPTA. And there are exceptions and everything, and that's fine. I'm not here to teach us FIRPTA. But what I am here to teach you is that if FIRPTA is ignored, if there is FIRPTA tax withholding not withheld, the person responsible is the buyer. It is the buyer's obligation. And so if the seller in Palm Beach County or somewhere else is selecting the closing agent, the buyer needs an attorney to make sure that FIRPTA has properly been complied with by either withholding or securing the proper, because IRS does come back and say, listen, you didn't withhold on this. We need $72,000. Okay? So make sure your buyer who's responsible is protected. Okay?
Which, by the way, many times a seller or a seller's attorney says to me, don't give any documents to the buyer with the seller's social security number. But legally, the buyer is entitled to that non-foreign certification that they sign that says, I am a citizen of the US or a permanent resident of the US, and here is my social security number to prove it. So the buyer is technically entitled to the seller's social security number. Scary.
Also, on that note, if the buyer happens to be a foreign person who, when they sell, is subject to FIRPTA, they will need that affidavit, because one of the questions that they ask is whether the transaction prior had complied with FIRPTA. So there's a valid legal reason why the buyer should have it also, besides that they're entitled to it.
And we always have copies.
Mhm.
Our copies are stored electronically. We have them usually within seconds. And now the biggest problem, where it may or may not be the realtor's fault, but remember, our job is not to assign fault. Our job is to get it done. Our job is to make our buyer, our seller, in our case, our realtor, happy, and not put their deposit at risk, and make sure they get the closing done so we get paid. Or if the closing cannot be done for one reason or another, that the person gets their deposit back. Okay? So what do we have to do? So we go to paragraph 8, which is our finding, which really is a total step-by-step guideline of how the financing provisions work. Okay? So we know when we get to the contract, there are four choices for financing. That it's choices A through D. That it's a cash transaction. And if it's a cash transaction, also always be realistic as to the effective date, the financing date, the closing date. You got sellers telling you, or you think you're protecting your seller by putting in the least number of days possible of everything, but you also have to be realistic as to everything. And sometimes it includes such things as the buyer says, look, here's my pre-approval letter, but it's Christmas week. My loan officer is on vacation with his family skiing, and he won't be back for another week. So could I have 7 or 8 days to do my loan application, whatever? Be realistic if you want to make the deal happen. We're not looking to trap people into default. We're looking to get a closing. We make no money off of default. None of us. Okay? So you could have a cash, you could have a financing deal. We could have assumption of existing mortgage. I don't know. When was the last time someone saw that happen? And a purchase money note and mortgage to the seller, rider C for terms, and you better have an attorney on your side if you're doing that. Okay? All right. So what are we looking for when it is a financing transaction? So first of all, you have to make sure that line 39 on the front of the contract is completed, which shows that I hate to tell you how many times I see that where this is not filled in, but the financing provision is checked. Okay? I saw that just yesterday on a deal. I'm not letting that realtor prepare an amended version of this contract. So anyway, we go back to paragraph 8 and we say, so first of all, how many days do we have for loan approval after the effective date? So it's not days for loan approval after the application, it's after the effective date. So let's understand that. If they're going to put it in on the 5th day or the 7th day, because the day ends on the 5th day ends on a Saturday, Sunday, or a holiday, so it may not be 8 days till the loan application is due. Do we want to give them 30? Now we're down to 23 days from the effective date left. Okay, so be realistic. I only realized just recently, after all these years, how realistic you have to be on that those days tick off very quickly. So you must designate, is it a conventional FA, VA, or other loan? If the loan officer comes back and says, I cannot get you a conventional loan, we have to go FHA. You need to come back and get an amendment to the contract that says this is going to be an FHA loan. On top of it, you're going to need an addendum for FHA VA loans. But regardless of that, you are in breach of the contract, the buyer, if you apply for an FHA loan and you were supposed to apply for a conventional loan. Okay? So everybody understand that. For purchase of a fixed or adjustable. Listen, as a seller, I want you to get your mortgage so we can close. I want you to put fixed or adjustable. There aren't that many adjustables out there in this day and age, but that's what I'm looking for, where you're open enough to get a mortgage. You're not restricting it. And with an interest rate not to exceed, you put that in there, I'm not accepting your contract, okay? Because that interest rate is based on your credit worthiness as a buyer. And I as a seller, when I'm looking at your contract, I do not know your credit worthiness as a buyer. Whereas person A may get a 7% loan today, person B may be only able to get a 9% loan, but puts in 7%, 30 days go by and they get denied. Okay? Absolutely not. That's the only line on the contract that you should leave blank. I don't think you could put NA in there on your form. I can't on mine. And that's going to be based on the prevailing rate based on buyer's credit worthiness. Okay? Do not put a rate in there. unless your buyer absolutely cannot afford more than a 5.5% mortgage. But the chance of that deal being accepted is going to be dropped by more than 50%, I promise you, especially if there are competing offers. And, you know, we've gone through 5 years ago or so that you also have to have the appraisal in that period of time and everything. Okay, good faith. Buyer must make that good faith application within how many days? 5, but remember, it could end on that 5th day could end on a Friday, on a Saturday, Sunday, or a holiday, which means it goes over to the next business day that is not a Saturday, Sunday, or holiday. And so now you may have gone 8 days and you only have 22 days left to get approval. Okay? Just keep all that stuff in mind. And they've got to use good faith and diligent effort. So many people want to sue over good faith and diligent effort. Very difficult to prove. What does it mean? Failure to use good faith and diligent effort can be considered shall be considered a default. For purposes of this provision, diligent effort includes, but is not limited to, timely furnishing all documents and information required by the mortgage broker, lender, and paying for appraisal and other fees and charges in connection with the buyer's application for financing, okay? Just be prepared that if you're going to declare a default or not accept the fact that the buyer was turned down for a loan, and base it on the fact that they did not use diligent effort, there's going to be attorney's fees involved in trying to prove that, okay? You are required to, the buyer, you have to make written requests to the buyer, if you're the listing agent, to get copies, to get information, okay? So you do need to send an email saying, I want information about that, okay? And the lender or the mortgage broker or the closing agent is authorized to disclose matters as appropriate and allowed. Allowed by who? There may be personal things in there that they can't give you, that's restricted by privacy rules and whatever. Now the tough part, okay? IV, V, and VI. You need to finally learn these, okay? And see what the options are. This is, of all the defaults I see where buyers lose the deposit, 90% come from these 4 paragraphs, okay? And while your E&O coverage will say the contract speaks for itself, my realtor insured is not a lawyer. They didn't have to, they're not allowed to advise the person on what they need to do and everything like that. Who is the buyer looking to for advice? You, okay? I'm going to tell you, practically, it is your responsibility if they lose a $30,000 deposit over any one of these paragraphs, okay? So, if within the loan approval period, the buyer obtains loan approval, then the buyer is going to notify the seller in writing prior to the expiration of the loan approval period. Do not wait. So first of all, in your calendar, in your Outlook, or whatever calendar you use for your file management systems, if you're using one of those, the day before or 2 days before, there should be an entry that pops up that says, Smith's loan approval period ends in 2 days, okay? Because you have to be prepared to start taking action. All right? Everybody has it on computer. Or if you're the type of person that still has a written diary book, then it should be written in there in red 2 days before and pray that you open it on that day. So you must provide the proof prior to the expiration of the loan approval period. What happens if I provide it afterwards? I don't know. We'll see. If buyer is unable to obtain loan approval within the loan approval period. Okay. Does it say buyer was denied loan approval period in the loan approval during the loan approval period? No. It just says if unable to. So if I didn't get a letter that says I'm not approved, or we need 3 more days or whatever, they haven't been approved in the loan approval period, and some action must be taken. What do we do? Well, the buyer is satisfied with the buyer's ability to obtain loan approval and proceed to closing. Then the buyer is going to provide written notice to the seller saying, I have not been approved, but I'm very confident that I'm going to get loan approval, period. So basically, I'm waiving the loan approval, and I'm going to proceed to closing as if I had the loan, okay? You don't become a cash buyer. You're still a loan buyer, okay? But you've now waived that contingency period, okay? Now, if buyer is unable to obtain loan approval within the loan approval, or cannot timely meet the terms of the loan approval, okay? So we have 2 things. One, I didn't get loan approval, or I got loan approval, but I cannot meet the terms. What's the terms? The term is that the seller, the condominium association must provide a blah, 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 whatever. And you can't get it because the condominium association is broke or whatever. I'm just making, Adam, what could be something there? I drew a blank.
We've just had that where, let's say the condo doesn't have the milestone inspection, or they put it off. I know the law changed, but we've had situations where there's something that they need to provide and either they don't have it or there's no one to respond to.
Okay, so if the seller doesn't get approval, or they get approval but cannot timely meet the terms of that loan approval after the exercise of good faith, the buyer may terminate this contract by delivering written notice of termination to the seller prior to the expiration of loan approval period, whereupon provide buyer is not in default on the contract. In other words, they've given the second deposit, they haven't done anything else of default, they're going to get the deposit back, and they're going to what answer do you get? You always get back, send me the letter of denial, okay? There may not be a letter of denial. And, I mean, as attorneys, we send back for you that says, show me where it says I have to give you a letter of denial. We only have not received loan approval. How do I prove a negative? I can't. I could just say, I could ask the lender, I could ask the broker for something that says, as of this date, you are not approved. But you haven't been denied, okay? So you don't have to have a denial letter to cancel at the end, prior to the end of the loan approval period, okay? Does everybody have that? That is the point of time, so that 2 days before, when it flashes up on your screen, 2 days left to loan approval period for the Smith deal, you have to consider what action I'm going to take. I need to talk to the lender and find out what's going to happen. Let's not waste anybody's time if we know they're not going to get approved. And
Barb,
yes,
can I ask you a question?
yes.
Because lately I've been having challenges with this specific condition of the approval, which is the appraisal. The new contract specifically outlined on line 96 the appraisal that the buyer should have, of the lender, or the buyer's mortgage should have received the appraisal or the evaluation, whatever they want to name it, satisfactory. So if the contract is subject to financing, at the same time, it is subject to appraisal, correct?
Yes,
Okay, so many agents in this buyer's market wants to make the contract clearly subject to the appraisal. So they include the appraisal rider to the contract. In your opinion, your legal opinion, is the buyer properly protected if as a buyer's agent you do not include the subject to the appraisal contingency, or it's like putting twice the same contingency if you add the addendum, if you add
it's,
the rider?
I don't have the addendum in front of me, and we're going to discuss that next month, but it's two different contingencies, okay? So this contingency is that the lender is satisfied with the appraisal, and you
Okay.
have to have it within that period of time, okay?
Uh-huh.
The appraisal contingency rider has to do with what if it doesn't appraise? Am I, up or down? Am I willing to go forward and put up a little more money
Correct.
to do this? So there are
And I
two
get it, but
definitions. Now, it's always used to be used in the case of a cash deal. It's very important for that. However, what I've seen is, okay, I'm going for a 40%, 50% loan to value mortgage. The lender doesn't care if it
I
appraises
agree.
$1,000 less. So
I
then
agree.
it should be used in that also. 80% loan to value, it's not going to make a difference.
Yeah, I agree. But the interpretation of the common agent is, for the common agent, is confusing. Like I have a listing right now that we all have the doubt that it's going to appraise. I'm the listing agent. The buyer's agent included the contingency rider. And I'm okay, I get it. The buyer is concerned. The buyer wants, I agree with you. The interpretation is that it is the buyer, the ones that want to make sure that the property appraises. So she puts the rider. I narrowed down the timeline of the rider because I didn't want to have an appraisal contingency open for 30 days, like she stated in the rider. So I narrowed down to 15 days. So then she goes, and she's an experienced agent. Okay, I have no control on the bank. I have no control on how long it's going to take to have a complete appraisal. I said, well, but we cannot have an open contingency when we are having a 21-day loan approval. So she goes, it's either like that, like I'm presenting to your seller, or I remove the contingency. And I'm like, you're contradictory. It doesn't make sense what you're saying.
So you're
But
fighting over 6 days.
exactly. But at the end, my concern is no matter if I have the buyer or the seller, because I understand what you're saying. If the appraisal doesn't hit value, it is up to the lender to make that appraisal a condition for the loan approval. But at the same time, if you go to line, it's what line, and the second page is line 130. 100 and it starts at 128. It says seller's default or inability of satisfy other contingents of this contract, and then it says number 2, property related condition of the loan, other provision on this contract excluding the appraisal. So it's like I get sometimes there's like confusion. What about if the buyer doesn't care about the property doesn't hit value because the rider is not there, but then after the loan approval, it's part of like an issue because let's say, I don't know, a week before closing, the lender decides to have a second appraisal, and then appraisal constitute a problem on the loan approval.
Well, that's a whole different issue. I mean, if the lender decides to get a second appraisal, that's strictly a complex legal issue. So we'd have to see
Because
about.
line 129 specifically says excluding the appraisal valuation.
Yes, that's it. So at that point, the buyer would probably be in default.
Correct.
Yes.
Art, I've done this with other realtors in the past, and basically we created a clause that says something to the effect of the appraisal ordered by the buyer's lender must be completed at least 2 days prior to the end of the loan approval period. And that way you've set your deadline, you know that the appraisal's done, and even if they order a second.
Do you mean, Adam, that by adding that language, the appraisal requested by the lender, the appraisal due date lines up at the same time with the loan commitment period?
Correct.
You
And
buy
I
it
put
over
2
4
days,
days
I
at
put
that
2 days
point. But
before, because that gives
listen,
everybody
guys, we're
approve.
running out of time. You know, that's an issue that has been around for a long time because this contract that term is at least 5 years old in this contract.
No, but it changed in December because before it didn't say that.
Right.
That was not part of that line. That the whole appraisal contingency thing, line 96 is part of this new contract that was revised in December. So that's why not everybody's using the rider because it's built into the contract.
That's been there for 5 years, that part. Anyway, but I do understand, and you know what? You have to make a decision. We're accepting it or we're not accepting it, or we're going to negotiate it. There's no law. That's good. That's just whatever you consider to be best practices. And like you say, you don't even think it's going to appraise yourself. So, you know, you need to negotiate it, but if you're going to ask the lender to do the appraisal early, you need to make sure that lender knows. You know, they're not going to see that, you know, you have to point it out to them. In the beginning, when this terminology, when this language was added to the contract ages ago, we told every realtor to make sure the loan officer knew, because in other states, they didn't know. A California lender did not know that they must have the appraisal during the loan approval period, that it was no longer acceptable for it to come in afterwards. So you just need to let them know. Okay, so what do we do now? 2 days popped up. We're at the end of the loan approval period in 2 days. And what do we do? So you have two options. You could either send to the you can either send a letter that says we didn't get it, we didn't get loan approval, we cancel, or you could extend an extension of the loan approval period. Now, so often I am seeing realtors submit that form extension that has checked the box that they use, that they extend the closing date, but they don't extend the loan approval period. And the whole reason they're extending the loan, the closing date, is because they don't have loan approval yet. So you have to make sure you check the right box, okay? So now we've dealt with the two major III and IV. Those are the two major reasons why people are losing buyers are losing their deposit, until we get to V. If buyer fails to timely deliver any written notice. Oh, it's coming in 2 days, I'll be okay. Okay? So I'm not even going to bother to cancel or ask for an extension. And who is making this decision? The buyer? No, the realtor, right? And usually it's a decision made by the realtor because they haven't been keeping track. And that's what I'm finding out. So if you don't deliver any written notice to the seller prior to the expiration, then the buyer shall proceed forward with this contract is the paragraph A had been checked as the effective date, as of the effective date. Okay? So what does that mean? It means you're now a cash buyer, and even if you go forward with your loan, you're not automatically entitled to that extension that we talked about if the lender is not ready to fund, even though they've completed underwriting. You don't even get that extension because that says 8B has to be checked. And this says as if 8A had been checked. Also, if you don't send any notice, the seller has 3 days to terminate the contract by sending written notice. Okay? Which rarely do I see a seller do, because probably his realtor hasn't told him that he could do that. Because if he cancels, there's no commission. But the listing agent, you're going to get a commission no matter what, whether he sells it to A or B. Okay? You don't want your property to, if this seller's not going to, if this buyer's not going to get the loan, don't let it go through to the end of the period of time. Cancel it. Okay? So finally, if the buyer has provided written notice as provided in 8.3 I above, and thereafter fails to close, the deposit shall be paid to the seller unless failure to close is due to the seller defaulting or property-related conditions of the loan approval, but not appraisal valuation. Okay? So there's where we have the default. Does everybody get that? It's really, if you read through them and look at them as, you know, it's a perfect procedural step-by-step of what I have to do. On the 28th day, that's telling you what I have to do within 2 days. Okay? There's nothing you can do before that. It's not like you could rush the lender. Yeah, did you do the appraisal? Did you do this? Did you do that? But to save your buyer's deposit, to save your deal, to save everything, on the 28th day, you need to get to work and do III, IV, and V. Okay? Listing agents, look at VI. Okay? Oh, I lost my space. Okay. Okay. Crafting additional terms, like I said, what happens if they don't do it? You got to include that. Use specific, prefer precise language. Who is required to do what? By when must it be done? At whose expense? And what consequences if not done? Okay? You need to put that in there. And if you're going to attach addenda, if you're going to attach addenda, check the box. Now, sometimes I see contracts with boxes, checks, and no addenda attached, or one of them's missing. Because I know we write the contract first, we check the addenda, and then we go and prepare them. And sometimes, oh, I don't need this one, but I'm going to go back and take it off the contract. Or more likely than not, I see addenda attached that are not included in there. And if it's not checked here, they're not included in the contract. They're not incorporated, so you must check it. Okay? So next month, what I want to do, before I ask if there are any questions, oh, I am finishing on time. Next month, we're going to talk about all of the addenda, and there's been lots of changes, okay? How about that condominium addendum? All right? Isn't it beautiful with the milestone inspections and go
It
check?
is a nightmare. It's a nightmare addendum.
So I'll teach you how to do it, okay? Listen, the legislature can't figure it out. The lawyers can't figure it out. The condominiums can't figure it out. But you realtors are going to clear up the whole problem, okay? So in any event, any questions? Okay.
Hello, quick question. So if an addendum is not marked on the contract, but it is signed by both parties, it is still not included in the purchase and sale contract?
Well, it depends. So if the addendum, it says here that they're included and incorporated, which means that if they're not checked there, they're not included and incorporated. However, we write addenda between the effective date of the contract and the date of closing. So it could always be considered as included if both parties have signed it and it refers to the contract. What I'm telling you is be professional. What I'm
Right.
telling you is dot all your I's, cross all your T's. You are professionals, okay? And that's why I tell you to fill in every blank box, even if you're just copying the default number of days. Don't, to show I am a professional. I read this whole contract. I went over it with the buyer. I filled in every date. And here's what I do to show that I did that. I always change one date from the default to show that I just didn't copy. And that's the inspection date. I make it to 7 from 15 usually. Even if I make it to 14, I have, for one reason or another, I have changed one to show that I've read. And which one can't you put in? Does it say if left blank? The interest rate in financing. You cannot fill anything in that box other than a number, okay? And you don't want to put a number in there. If left blank based on their credit worthiness. Okay, one last thing, let me show you, is he was supposed to be here today, but I have a good friend. You guys use professional cleaners, I know. So, I mean, Chris tells me you use professional cleaners for before the pictures are taken to make it sparkle. And one of the nice things you could do sometimes, well, when a seller leaves, you may put in the contract that it says the house will be professionally cleaned after seller moves out. Or sometimes you realtors like to give your clients a gift and get the house professionally cleaned before they move their goods in. Chris Trujillo of True Cleaning and Disinfecting Services is a good friend of mine. His team of cleaners do an excellent job. Other realtors have told me what a great job they do. So if you want, there is his information. Okay? And just because he's a friend of mine, it's not a paid announcement. It is not a commercial that he has paid for. Okay? That's
Thank you.
just my recommendation. Did everybody learn something today? Did everybody have a good time?
This is one of the best trainings I got on legal things related to real estate.
Thank you, Daniel. I appreciate that. I try
As
not to do
always,
it
you're the
legally.
best. As always.
Yeah,
Thank you.
He knows
always.
us
Thank
already.
you. Okay. So let's
Marty,
all,
I'm gonna send you an email, so I rephrase my question in regards to the appraisal, and then you can do another seminar in connection to the appraisal, because I'm running into a lot of conversations with agents, and everybody, even attorneys, have different approach as far in the difference between the appraisal, and
it
I'll send
has
it to you so
been
you can have
like
it handy.
that. It has been like that since the contract changed. And next month, I am going to do the addenda. So send
Okay.
the information, send it to Julie and Adam also.
Mhm.
I will cover that in depth next month when I do the addenda. Next month
I
will be,
think it's important to teach agents the difference between the implications in the
well,
event that
get
the
them
appraisal.
here.
Yeah.
I'm teaching you 20 people.
Yeah.
Get
Mm-hmm.
them
Yeah.
here to me. Bring
Yeah.
your friends.
Yep. Yep.
Yeah, of
Bring
course.
your colleagues from your office and
Mhm.
let me kick some knowledge into them, okay?
Yeah.
And then the other thing is, so that's going to be August. In July, I'm going to do, for those of you do, I'm going to do leasing and
Okay.
all the different addenda you could write for leases.
Nice.
Okay?
Perfect.
And you can't write them. You need
You
me to
get
write
you
them.
you're gonna have a full house. You're gonna have to sell
Yeah.
your addendum writer for
Yeah.
listers.
That's okay. That's okay. There are things.
Yeah.
Stella, you will make a profit out of it.
Okay.
That's why I do this. So don't send me your, what does it say in the Statute of Liberty? Send me your what, your what, your what? No, send me your deals. Okay, send me your buyer reps, send me your seller reps, send me your closings, send me your tenant evictions, send me your leases, send me your partition cases, send me your quiet title. Send us all your good deals and all your deals that go bad. And we will try to keep your clients happy so you keep getting repeat and referral business, the
Perfect.
cheapest form of advertising. Okay?
Nice.
Have a great weekend, everybody.
Thank you.
Thank you. Thank you.
Thank you. You mean the 10 pounds that you pay? Okay.
Oh, there's end.